Good morning. Shall I start? Namaskar. Good morning, everyone. Trust that you all are fine at home and are safe with your loved ones. I am indeed very thankful to Dr. Mahesh Patel for bringing me into this platform to speak on today's topic, the necessity of expert evidence in criminal justice system. The criminal justice system, as we all know, is a set of agencies and processes established by governments to control crime and impose penalties on those who violate laws. It mainly consists of three parts: police, which undertakes investigations and is a law enforcement; courts for adjudication of cases where trials are conducted; corrections, which ensures an offender's sentence is carried out, whether it's time in jail or prison, probation, or community service. During the investigation of crimes and also during court trials, that we need experts' involvement for investigating agencies as well as courts to find out truth and punish the criminal and let off the innocent. There is a maxim which says, "Culebet in sua, arte perito es credendum." It is a legal maxim which means evidence should be given to one skilled in his peculiar profession, meaning thereby that everyone who is skilled in his own art is to be believed. Today what we see is that a society has become more dynamic. Things is going under rapid change. Due to the progress in science and technology, crimes have also become more complex in nature. Rule of law necessitates to bring social order and to curb the guilty to justice. Therefore, it is very much necessary to connect the scientific evidence and testimony of expert in criminal trials and prosecutions. The expert witnesses performs two primary functions. First, scientific function of collecting and evaluating the evidence, and the second is the forensic function, the opinion and its basis to the judge or the court. In criminal case, especially based on circumstantial evidence, science plays a crucial role, which helps in identifying the suspect and to ascertain the guilt or innocence of it. The emerging new types of crimes and their level of sophistication, the traditional methods and tools have now become out, and it is very much necessary to strengthen the forensic science for crime detection. Philosopher Plato once said that the necessity is the mother of invention, and therefore new inventions and tools for interrogation have been developed by scientists and experts over the years, which are being used in our criminal justice system. So we now briefly look at the history of expert evidence. From early times, the courts have been acting on the opinion of experts. The application of science and technology to the detection and investigation of crime and administration is not new to India. Although our ancestors did not know forensic science in its present form, yet scientific methods in one way or the other are followed in investigation of crimes. Its detailed references is also found in Kautilya's Arthashastra, which was written way back 300. Indians also studied various patterns of the papillary lines, that is, the lines on our fingers, thousands of years. It is also believed that they knew about the application and individuality of fingerprints, which they used as signatures. The use of fingerprints as signatures by people in India was just a ritual until it was scientifically proved that identity for fingerprints was flawless. During the 19th century, when the cases of death due to poisoning were a problem enforcement agencies, a need was felt for isolating, detecting, and estimating various poisons that are absorbed in human system. The first chemical examiner's laboratory was set up for this purpose at Madras under the Department of Health during 1849. Later, similar laboratories were set up at Calcutta in 1853, followed one each at Agra in 1864 and Bombay in 1870. These laboratories were equipped to handle toxicological analysis of viscera like heart, lungs, and stomach, biological analysis of strains of blood, semen, etc., and chemical analysis of food, drugs, and various materials to provide scientific support to the criminal justice delivery system within their limited means. Chemist Carl Wilhelm Scheele in 1776 found a way of detecting arsenic in corpus. This investigation was expanded in 1806 by German chemist Valentin Ross, who learned to detect in the walls of victims' stomach. English chemist James Marsh used chemical process to confirm arsenic as cause of death in 1836 in a murder trial. The earliest known use of expert witness in England traced to 18th century in a case of Fawkes versus Shadd, reported in 1782, 3 Douglas King's Bench 157. A harbour had decayed, and the question was whether it had anything to do with demolition of a sea bank erected to prevent the sea overflowing into some meadows. Thomas Smeaton, an eminent engineer, was called to give an opinion which was objected by the defendant. Lord Mansfield laid down the base of modern rules of expert evidence. Lord Mansfield held the opinion of scientific men upon proven facts may be given by men of science within their own science. With the development in the role of expert evidence in courts, expert evidence has now become the most important component of many civil and criminal cases. Fingerprint examination, blood analysis, and DNA fingerprinting are kinds of expert evidence used in criminal cases. In civil cases, the work of accident analysis, forensic engineer, accountants are important to assess the damages and costs in complex cases. As a result, forensic laboratories are established. The first forensic science laboratory in India was established in the 1952 in Calcutta. This laboratory became fully operated in the year 1953. The first central forensic science laboratory was established at Calcutta during 1957. The Indian Academy of Forensic Sciences, that is IAFS, was established in the year 1860. Now, with the development of technology, crimes related to stalking, cyber crimes have increased, and as a result, forensic electronic evidence have entered the courtrooms. Audio and video evidence have received recognition by courts. Voicemail recording, closed-circuit television, CCTV recording have become most common electronic evidence often used in litigation. Now, closed-circuit television recordings in or out of shops, houses or streets which record robberies, thefts, or any other type of crime, and kind of video recordings related to live threats are presented in courtrooms through electronic expert evidence. Let's understand the concept of evidence before defining expert evidence. The word evidence is defined by different people or agencies in many ways. Evidence, in a layman's language, as we call it, is the proof of facts presented at a judicial hearing, such as a trial. Evidence is that in which a court of justice is permitted by law to take into consideration for making clear or finding the truth of the fact or point of issue. The word evidence is originated from the term evidentia, which means to show clearly, to make clear, to cite, to discover clearly, to assert, or to prove. Evidence is something which serves to prove or disprove the existence or non-existent facts. According to Webster Dictionary, evidence is that which is legally submitted to a competent court tribunal as a means of ascertaining the truth or otherwise of an alleged matter of fact under investigation. Under Section 3 of Indian Evidence Act 1872, which defines evidence as a means and statement which the court permits or requires to be made before it by witnesses in relation to matters of fact under are called oral evidence. 2. All documents, including electronic records, produced for the inspection of the court, such statements are called documentary evidence. Thus, under Indian Evidence Act, the definition of evidence includes both oral and documentary evidence. Now, what is the definition of experts? According to Black Law Dictionary, experts are men of science, educated in the art, or person possessing special or peculiar knowledge acquired from practical expertise. Lawson defines an expert as a person who has special knowledge and skill in the particular calling in which inquiry relates. In the shorter Oxford English Dictionary, an expert has been defined as a person with the status of an authority in a subject by reason of special skill, training, or knowledge, or a specialist. Under Indian law, law governing expert evidence consists of 3 parts, that is, enacted laws, case laws, and court conventions. Enacted laws, statutes governing expert evidence are Code of Criminal Procedure, 1973 under sections 53, 53A and 293. Next is Identification of Prisoners Act 1920 under sections 4, 5 and 6. And the third is Indian Evidence Act 1872 under sections 45 to 60, 73 and 112. Section 53 and 53A CRPC made the provisions for the examination of accused by a registered medical examiner when a person is arrested on a charge of committing an offence of such a nature and alleged to have been committed under such circumstances. Under Section 53A, when a person is arrested on a charge of committing an offence of rape or an attempt to commit rape, and that there are reasonable grounds for believing that an examination of his person will afford evidence as to the commission of an offence. Section 293 mentions the special provisions relating to reports of certain government scientific experts submitted. A report submitted by chemical examiner, chief controller of explosives, director, fingerprint bureau, director, Hafkin Institute of Bombay, director, Central or State Forensic Science Laboratory, as expert opinion may be used as evidence. Under the provisions of Section 73 of Indian Evidence Act and Section 4, 5 and 6 of Identification of Prisoners Act 1920, the law enforcing authorities and courts have been empowered to take fingerprints of a person for the purpose of investigation or identification. The court necessarily seeks the opinion of an expert under Section 45 of Indian Evidence Act 1872, which deals with opinion of experts. Section 45 reads as follows: when the court has to form an opinion upon a point of foreign law or of science or art, or as to identify handwriting or finger impressions, the opinions upon that point of persons especially skilled in such foreign law, science or art, or in questions as to identity of handwriting or finger impressions are relevant facts. Such persons are called expert. This section is an exception to the rule as regards the exclusion of opinion evidence, because opinion evidence, we know, is based on inferences. Opinion of experts here are relevant a point of foreign law, science, art, identity of handwriting, and finger impressions. Therefore, an expert to be competent as a witness need not have acquired his knowledge professionally. It is sufficient as far as the admissibility of the evidence goes if he had made a special study of the subject or has acquired a special knowledge. So, an expert is anyone with a special knowledge, skill, experience, training, or education in a particular field or discipline that permits him to testify to an opinion that will aid a judge. That is, that will help a judge or jury in resolving a question that is beyond the understanding or competence of a layperson. An expert witness is an expert who makes his or her knowledge available in a court to help it understand the issues of a case and reach out to a sound and just decision. Expertization involves an interaction between different subjects. As the consequence of advances in science and technology, there has been an increasing necessity for court of law to rely on expert testimony on part of expert witness to support the view of the person who called him. Suppose the prosecution has called the expert witness. So we generally see that who makes themselves available on hire to pledge in their own favor on favor of the party paying them. Despite this, the expert evidence is taken as truth, which helps the court to decide a case which is complex in nature. In law of evidence, opinion means any inference from observed facts. Other section that deals with expert opinion are section 47, which says opinion as to handwriting when relevant. Section 48, opinion as to existence of right or custom when relevant. Section 49, opinion as to the usages, tenets, etc. when relevant. Section 50, opinion on relationship when relevant. And section 51, grounds of opinion when relevant. Now, what is the importance of expert witness? The use of expert testimony in the courtroom has become a common practice. Virtually in all cases, the scientific expertise or technical knowledge or need of expert witnesses and their testimony is required. The areas of the expert evidence is generally set out in three forms, that is, pure opinion of expert evidence, scientific expert, and non-scientific evidence. An expert is not a witness of fact. His evidence is really of an advisory character. It is the duty of an expert witness to furnish scientific criteria for testing the accuracy so that judge may be able to conclude the case. Expert evidence is only a piece of evidence, and whether weightage is to be given to it has to be judged along with other corroborative evidence. Evidence of this nature is ordinarily not conclusive. Such evidence is not taken into consideration unless corroborated by other evidences. In Srichand versus Srimati Ram Devi, reported in AIR 1980, Allahabad 294, it was held that when a court permits the evidence of an expert to be brought on record on a technical matter, it does not abdicate, that is, it does not give up its function to judge for itself whether the opinion of expert is correct or not on a matter in issue. The question of whether a witness is an expert is a question of fact for the judge. A particular or special knowledge of a subject that has been acquired through scientific study or experience can qualify a witness as an expert. In another case of Ranjit Singh Brahmjeet Singh Sharma versus State of Maharashtra, reported in 2005, Criminal Law Journal, page 2533, the apex court held that the admissibility of a result of a scientific test will depend upon its authenticity. Therefore, importance of expert evidence is for helping the judge to determine the extent of liability, which may vary due to such testimony that is imposed on an offender. Expert witness has an advantage of a particular skill or training, since judges are not properly equipped to draw inferences from facts in certain technical matters. Expert evidence is sought most obviously in disputes regarding detailed scientific or technical knowledge. The purpose of expert opinion is primarily to assist the court in arriving at a final conclusion. Such report is nonetheless not binding upon the court, where the eyewitness and the other prosecution evidence are trustworthy, have credence, and are consistent with the I version given by the witnesses. In such cases, the court may take into consideration the opinion of the expert witnesses. The court will be well within its jurisdiction to discard the expert opinion. In such case, court has to critically examine the basis on which the expert opinion is made, the reasoning given by the expert, approach and experience of the expert to come to a conclusion as to whether the report can be safely relied upon. Now, we'll talk about admissibility and credibility of an expert evidence. The court is expected to analyze the report and read it in conjunction with the other evidence on record and then form its final opinion as to whether such report is worthy of reliance or not. An expert opinion is admissible to furnish the court a scientific opinion which is likely to be outside the experience and knowledge of a judge. This kind of testimony, however, has been considered to be of weak nature, as expert is usually required to speak not of facts but of opinions. In State Delhi Administration versus Paliram, reported in AIR 1979 Supreme Court, page 14, it was held that the value of expert opinion rests on the facts on which it is based and its competency for forming a reliable opinion. The importance of an opinion is decided on the basis of the credibility of the expert and the relevant facts supporting the opinion so that its accuracy can be cross-checked. In another case of Mushir Khan and another versus State of Madhya Pradesh, reported in AIR 2010 Supreme Court, page 62, it was held that the infirmity of expert evidence consists in this, that it is mostly matters of opinion and is based on facts detailed by others or assumed facts or opinion against opinion, and experts are selected by parties calling them. Expert evidence is, however, of value in case where the courts have to deal with matters beyond the range of common knowledge and they would not get along without it. In matter of scientific knowledge, all the facts have come within the personal observation of experts. It is also a known fact that experts usually come with a bias on their minds to support the cause in which they are called. Little weight will be in general attached to the evidence which they give unless it be obviously based on sensible reasoning. The court sees all the materials which includes the expert to come to his conclusion so that court, although not expert, may form its own judgment on this case, on the materials. In the case of Ramesh Chandra Agarwal versus Regency Hospital Limited and others, reported in AIR 2010 Supreme Court, page 906, the Honorable Supreme Court broadly dealt and interpreted the scenario of expert evidence and held that an expert, I would read what has been held. The court said an expert is a person who devotes his time and study to a special branch of learning. However, he might have acquired such knowledge by practice, observation, or careful study. The expert is not acting as a judge or jury. It was further held that in order to bring the evidence of a witness as that of an expert, it has to be shown that he has made a special study of the subject or acquired a special experience therein, or in other words, that he is skilled and has adequate knowledge of the subject. The real function of the expert is to put before the court all the materials together with reasons which induce him to come to the conclusion, so that the court, although not an expert, may form its own judgment by its own observation of those materials. An expert is not a witness of fact, and his evidence is really of an advisory character. The duty of the expert witness is to furnish the judge with the necessary scientific criteria for testing the accuracy of the conclusions, and so as to enable the judge to form his independent judgment by the application of this criteria. No expert can claim that he would be absolutely sure that his opinion was correct. Thus, the court held that first and foremost requirement for an expert evidence to be admissible is that it is necessary to hear the expert evidence. The scientific question involved is assumed to be not with the court knowledge. The other requirements for admissibility of expert evidence are that the expert must be within a recognized field of expertise, that the evidence must be based on reliable principles, and thirdly, that the expert must be qualified in that discipline. Now we talk about the kinds of expert witnesses to know as to how they are necessary for the purpose of investigation and for the courts to deliver justice. The first one is medical opinion. In criminal administration of justice, the scope and ambit of medical science is not only limited to human body, medicines and other phenomena, but also extended to the chemical innovations, investigations, technical analysis, new methodologies, etc. In a criminal trial, the judge has to rely on knowledge and opinion of certain experts. So medical evidence is a part of expert opinion. Now, what is the importance of medical evidence? Medical evidence plays a very crucial role in determining various forms of the crimes committed against the human body. Medical evidence is only corroborative evidence, and it is not substantive evidence. Medical evidence consists of doctor's report of examination, a report of ballistics, that is bullets, firearms, or fingerprints experts, or of the chemical examiners. The doctors or other experts give oral evidence. Medical evidence prosecution as great.
Yes, sir. Okay, sir, I am online.
The doctors or others, the medical evidence used by the prosecution has great corroborative value. In a given case, it may help to prove that the injuries alleged would be the cause of death. The expert evidence given by a medical person aids the court in concluding the actual reasons of commission of crime. Evidence of death can be obtained through post-mortem report, and it becomes very helpful in deciding the guilt of the accused. Courts have always taken doctors as witness of truth, even not deposed in court. If there is doubt regarding the statement of doctor, then the direct evidence is accepted. The opinion of doctor's evidence taken as contradictory. A medical practitioner, we know, is neither a prosecution witness, defense witness. He is only an expert witness, even though he frequently appears as a prosecution witness. Once the expert opinion is accepted, it is not the opinion of the medical officer, but it forms the opinion of the court. So the evidence alone will not convince the court beyond reasonable doubt unless the same is corroborated with other direct evidence. When a medical person is called as an expert, he He is not to witness the facts because his evidence is not direct evidence on how an injury in question was done. He only gives his opinion only on probabilities. Now, in recent times, we see there is dog tracking evidence which are being included as an expert evidence. In the investigation of criminal case, which and is also facilitated by use of tracker dogs, where other evidences are not helping in determining the guilt of the accused. During investigation of criminal cases, some of which may not have an apparent proof of guilt, the police takes assistance of tracker dogs for detection of crime. In recent times, investigating agencies often use the services of tracker dogs. In the case of Babu Maqbul Sheikh versus State of Maharashtra, reported in 1993 Criminal Law Journal, page 2808, the High Court analyzed the value, utility, and admissibility of tracker dog evidence. The tracker dog had helped the police in recovering the bag, clothes of the accused, and also led the police to the house of the accused. The evidence in criminal cases, and in particular ones where the charges are serious, undoubtedly must pass the dual test of absolute reliability and flawlessness. Tracker dogs cannot be influenced is something which is very strongly in its favor, and this import this class of evidence a special type of acceptability. It is now universally acknowledged that in detecting drugs, where every other form of human ingenuity and gadgets are capable of being falsified, it is virtually impossible to avoid detection by this mode. This has been found to be most reliable and foolproof way of detecting crimes. Now we talk about very important expert evidence which comes from DNA analysis. DNA means deoxyribonucleic acid, which is found in all bodily fluids, tissues, etc. It is found in every single cell of a person's body, and each cell has identical DNA, except in identical twins. DNA is acid sometimes called the building block or genetic blueprint of life, which was first discovered by the scientists Francis H.C. Crick and James T. Walton in 1953. The foremost legal application of DNA testing occurred in 1986 in a famous case of Collins. DNA structure varies among each individual. It carries a genetic code which can be used for proving human character, body characteristics, behavior, etc. DNA can be found in human body and samples from semen hair, blood, flesh, which can establish a DNA matching with the DNA of another human being. There is no legislation dealing with issues on DNA evidence and its ability. The Apex Court has put the opinion of DNA expert under Section 45 of the Indian Evidence Act. DNA technology is used as the latest tool in forensic science in identification of criminal cases by analyzing various objects recovered on the crime spot, like any body fluid, hair root, fibers, etc., which are associated with the crime and accurately linked to the perpetrators of the crime. This technology is utilized as a new form of circumstantial evidence which is placed on a higher footing than the direct and ocular evidence because of its objectivity, scientific accuracy, flawlessness, and impartial character. DNA technology has proved to be a worthy investigative tool for releasing the innocent citizens and bringing from the person responsible for serious crimes. There is a concept where DNA is and self-incrimination has been discussed by various courts. The most important case is in Selvi versus State of Karnataka, reported in AII 2010, Supreme Court 1974. The Supreme Court held that the taking and retention of DNA samples, which are in the nature of physical evidence, does not face constitutional hurdles. The use of material samples such as DNA for the purpose of identification does not amount to testimonial act against Article 23 of the Constitution. Referring to the case of Thograni versus Damavanti versus State of Orissa, reported in 2004, Criminal Law Journal 4003, it was held by the Apex Court that the only restriction for issuing a direction to collect the blood sample of the accused for conducting DNA tests would be that before passing such direction, the court should balance the public interest vis-a-vis the rights of the accused under Article 23 and 21 of the Constitution of India in obtaining evidence tending to confirm or disprove that the accused committed the offense concerned. The next methodology which is being used recently is narco-analysis test. Narco-analysis test is a psychotherapy test which is conducted with patient in a sleep-like state induced by barbiturates or other drugs. Basically, the term narco derives from Greek word narke, meaning anesthesia, which refers to the diagnostic and psychotherapeutic technique which employs psychotropic drugs, particularly barbiturates, which act as central nervous system depressants, by virtue of which a wide spectrum of effects are produced, ranging from mild sedation to anesthesia. It is concluded that while undergoing this test, patient cannot create a lie. Narco-analysis test from criminal investigation is a test for criminal investigation is very valuable technique which would profoundly affect both the innocent and the guilty, which hastens the cause of justice. The procedure is helpful in finding out the facts relating to an offense. It should be used and utilized, and the court should not obstruct the conduct of the exercise. The narco-analysis test is conducted by administering sodium pentothal dissolved in distilled water, depending on the person's sex, age, health, and physical condition, and this mixture is administered intravenously along with 10% of dextrose over a period of 3 hours, which with the help of anesthesis. The rate of administration is controlled to drive the accused slowly into a hypnotic substance. The effect of this biomolecule results of an individual is evident as the drug depresses which control nervous system, lowers the blood pressure and slow the heart rate, which results in lack of inhibition. Then the subject is interrogated by the investigating agency in the presence of the doctors. The revelations made during this stage is recorded in videos. The underlying theory is that a person is able to lie by using imagination. In this test, the subject imagination is neutralized and reasoning faculty affected by making him semi-conscious. Now we talk about polygraphy or lie detector test. A polygraphy test or the lie test is an instrumental measurement which records the psychological responses relating to the blood pressure, pulse respiration, etc. While the subject is asked to answer a series of questions for the theory of false answer, the theory behind the polygraphy test is that the culprit is righteously caught while getting the results from the measurement of hyperarousal state. The test is conducted where the expert prepares a set of questions in the different logs as irrelevant question, relevant questions, controlled questions, and then the comparison of these questions will be diagnosed about the case provided the information collected from the investigation officer and the suspected person. The basis objective of this test is to mitigate the possibility on the part of subject which would be triggered by unexpected questions to found the deception in the case. The next is handwriting expert. The opinion of handwriting expert is relevant when the court has to form an opinion as to the identity of disputed handwriting or signature. The quality of his opinion would depend upon the sounded reasons. In the case of Ramachandra versus State of UP, reported in AIR 1957 Supreme Court, page 381, the Apex Court held that it is unsafe to treat expert handwriting opinion as sufficient basis for conviction, which is relied upon and supported by the internal and external evidence. The court again pointed out in the case of Ishwari Prasad versus Muhammad Isa, reported in AIR 1963 Supreme Court 728, in which it was held that the expert evidence of handwriting can never be conclusive, as after all it is the opinion evidence. The fundamental problem with the expert opinion on handwriting is the non-scientific nature of expert opinion on comparison. While comparing handwriting samples, number of variables are compared. The variable on which the expert base their opinion are only evidence of some techniques, tendencies, which can also be affected by numerous extraneous factors such as state of mind, haste, self-conscious, intoxication, etc. Although evidence of handwriting expert is a weak type of evidence, yet the court has power under Section 73 of the Indian Evidence Act to examine the handwriting itself. The handwriting may be proved on admission of the writer and the evidence of a witness in whose presence he wrote. This is the direct evidence, and if it is available, the evidence of any other kind is rendered unnecessary. Besides this, three methods are to be taken into consideration. First, handwriting of a particular individual who is familiar with the handwriting of a person. Second, the comparison of the handwriting to scrutinize it. And thirdly, it must be taken in the presence of the court. The next methodology is fingerprinting, and the experts are fingerprint experts. The science relating to fingerprint analysis and comparison have developed to a great extent as an exact science and leaves no room for doubt or mistake. It is quite possible to compare the impression taken from fingerprints of an individual with the disputed impression. The courts can themselves examine the impressions. The importance of fingerprints in criminal investigation is unique and permanent in nature. In Muhammad Khan versus State of Rajasthan, reported in AIR 1997 Supreme Court, page 2960, it was held by the Honorable Court that suspicious circumstances relating to an offense can be sorted out with the genuineness of the specimen fingerprint. Again, it was held that reliability of the fingerprint evidence in that particular case was that glass on which fingerprint of the accused was found seized were 10 days ago thereafter and while accused was in custody. There is a possibility of tampering and fabrication of evidence. In such cases, fingerprint evidence could not be relied upon and could form the basis of conviction. In The case of Prakash versus State of Karnataka, reported in 2014-3, RCR page 744. It was held that taking of fingerprints of accused, it would be eminently desirable that fingerprints were taken under the orders of magistrate. There are possibility of police fabricating the evidence, and to avoid an allegation for such a nature, this would equally apply to ascertaining evidence against a suspect. In this case of a murder, accused did not give fingerprints voluntarily, but perhaps unwillingly and in what seems to be in a deceitful manner. The entire exercise of identification of accused from fingerprints was therefore shrouded with mystery and therefore could not be given any credence. Now I would like to conclude that criminal law and the administration of criminal justice are fast developing, and we need to keep up with these developments. The law is not and cannot be static. It must change with the changing times and needs. Thus, for the administration of justice, it is duty of a judge to test the credibility and its evidentiary value of the report of the expert with reference to nationally and internationally accepted texts to satisfy judicial conscience. Caution is required to be observed by cross-checking any pitfall, and all the pitfalls has to be avoided. The courts normally are looked upon. The courts normally looks upon the expert evidence with a greater sense of acceptability, but as the courts are not absolutely guided by the reports of experts, especially when they are perfunctory or unsustainable, an expert witness is a professional expertise in this area. Effect of this evidence cannot be undermined. Evolution of technology, use of scientific techniques in criminal investigation, and the deposition of expert witnesses have secured and ensured the victims of the justice by just depending upon the statement of witnesses present at the scene of the crime. Though not conclusive on matters, the expert opinion, I would feel, is definitely very crucial for the administration of criminal justice system. Thank you very much.
Thank you, Mehsana. Good morning, all of you. I am Kauchalraj Upadhyay, Assistant Professor S.M. Shah Law College, Mehsana. I would like to thank Nagesh sir that he has spared his valuable time for the law students and advocates, and also to the faculty members by giving a lecture on the importance of expert evidence. Sir, we are highly delighted and we thank you very much on behalf of S.M. Shah Law College that you have given a guidance on expert evidence, narco-analysis, psychotropic drugs, etc. Once again, sir, I thank you very much to be a part of this criminal justice system webinar. Thank you so much, sir.
Thank you very much. It was indeed a pleasure, and I hope I'll be invited again. Thank you so much.
Definitely. Sir, it will be our pleasure. Thank you so much, sir.
Thank you very much.